Why was the judge yelling at the prosecutor on day 7 of the Kyle Rittenhouse murder trial, and could it result in a mistrial? Well, let's break it down. My name is Christopher Melcher. I'm a California attorney and legal commentator. I started my career in criminal defense, and I want to go through this incident in detail that the regular media has not done. You may have seen the video of the explosive encounter the prosecutor had with the judge on day 7 of the trial, but you may not have heard the questions that the prosecutor asked that triggered the anger of the judge. In this video, I will show you clips of the questions that were asked, whether those were proper or not under the law, the judge's reaction to that, and what this could mean for the trial. There were 2 incidents that happened on day 7 of the trial while Kyle Rittenhouse was under cross-examination by the prosecutor. Kyle Rittenhouse decided to take the stand and testify in his own defense. That's his right. And then the prosecutor asked this line of questioning.
Since August 25th, 2020, you've had the benefit of watching countless videos of your actions that night, correct?
I've seen certain videos, not all of them. I've seen the majority of them actually here during the trial.
You've also had the opportunity to read articles. People have written interviews, things like that, about what happened that night, correct?
I do my best to avoid what people write on the internet. A majority of it's not true.
You have also sat here through 8 days of trial, correct?
Yes.
You've also had the opportunity to listen to the testimony of all 30-some witnesses that have testified in this trial so far, correct?
Yes.
And after all of that, now you are telling us your side of the story, correct?
Correct.
I'm going to ask you folks to go in the library for just a second. Please don't talk about the case.
The court stopped the proceedings before Kyle answered the question and excused the jury. The exact question was, after all of that, now you were telling us your side of the story. The implication is that Kyle was able to craft his story after listening to witnesses testify, watching video of the incident, and that had Kyle chosen to speak earlier, his story would have been different. That may be true, but a prosecutor can never comment on the defendant's exercise of his right to remain silent. That's guaranteed to us in the United States under the Fifth Amendment. It's an important right because otherwise we would have to bear evidence against ourselves in a criminal prosecution. The state must prove guilt beyond a reasonable doubt without any assistance by the accused. It is improper for a prosecutor to comment on a defendant's exercise of the right to remain silent. We do not infer guilt from the exercise of that right. So let's see what the judge said about this.
You need to account for this.
Your Honor, I don't want to jury here. He's commenting on my client's right to remain silent.
No, Your Honor. I am making the point that after hearing everything in the case, now he's tailoring his story to what has already been introduced.
The problem is, this is a grave constitutional violation for you to talk about the defendant's silence. And that is, and you're right on the borderline. And you may be over, but it better stop.
Understood.
This is, I can't think of the case, the initial case on it, but this is not permitted. All right. Ask the jury to come in, please.
The court issued that warning and let the proceedings go forward. The court can give what's called a curative instruction or admonishment, where the judge instructs the jury to disregard that line of questioning and not to infer any guilt from the exercise of the right to remain silent. The problem is that calls attention to this line of questioning that the jury might not have understood the significance of it when it heard it the first time. 20 minutes later into this cross-examination, the prosecutor did something again that outraged the judge. Let me give you the background. At the beginning of the trial, the prosecutor asked for permission to use evidence of a August 10 statement that Kyle Rittenhouse had made. There's apparently a video of Kyle that I have not watched that shows some people looting a convenience store and Kyle saying on tape that he wished he had his AR-15 rifle so he could shoot them. The prosecutor wanted to use that statement as evidence of Kyle's intent 15 days later, August 25, when these killings occurred, to show that his state of mind when he went out there on August 25 was to kill people who were damaging property. The court would not allow evidence of these August 10 statements, finding that the two incidents were not similar enough to be admissible. The law generally precludes a prosecutor from using evidence of prior statements or actions to prove that the defendant acted in conformity with that statement on the date in question. In other words, Kyle Rittenhouse needs to be convicted based on what he did August 25, not on what he did or thought on August 10th. There is an exception if these prior acts or statements showed a common plan or purpose. And that usually happens when somebody does the same thing over and over again, such that it's clear that the state of mind of the defendant was the same on the date that the killings occurred. Right or wrong, the judge said that this evidence could not come in, but as with all evidentiary rulings, they are able to revisit those later on if something changes during the trial. Later in this trial, Kyle Rittenhouse testified, and he said he had no intention on shooting anyone when he went out there on August 25. The prosecutor thought, hey, that's inconsistent with the August 10th statement. And instead of asking for permission outside the presence of the jury to now use the August 10th statement to cross-examine Kyle Rittenhouse, the prosecutor gave himself the green light and asked the question. Here's what he asked.
Do you understand that there's a difference between using deadly force to protect yourself and using it to protect property, correct?
Yes.
And you'd agree with me that you're not allowed to use deadly force to protect property, correct?
Yes.
But yet you have previously indicated that you wished you had your AR-15 to protect someone's property, correct?
I'm going to ask you to go into the library again for a moment, please. Please don't talk about the case.
The judge stopped the proceedings before Kyle answered the question. So the question was, you had previously stated you wished you had your AR-15 to protect someone's property. And here's the judge's reaction.
Your Honor, Mr. Binger is either forgetting the court's rulings or attempting to provoke a mistrial in this matter. He knows he can't go into this, and he's asking the questions.
First of all, Your Honor, this was the subject of a motion. I'm well aware of that. And the court left the door open.
For me, not for you.
My understanding of
You should have come and asked. I said, I denied it, or I indicated a bias towards denial is what I did. Held it open with a bias towards denial. Why would you think that that made it okay for you, without any advance notice, to bring this matter before the jury? I was astonished when you began your examination by commenting on the defendant's post-arrest silence. That's basic law. It's been basic law in this country for 40 years, 50 years. I have no idea why you would do something like that. So I don't know what you're up to.
May I respond?
Yes.
We filed an other acts motion on this exact issue because, in my mind, and I argued this, it is identical to what was going on the night of August 25th, in the sense that the defendant was using this exact same weapon. He was using it in a manner to try and protect property.
No, he wasn't.
Your Honor, with all due respect,
I'm not going to rehash the motion. That's absolutely untrue. No. Your arguments of record, my comments are of record, and why I ruled as I did is of record. There's nothing that I heard in this trial to suggest anything's changed. Even if you're correct in your assumption that you know more than I did at the time, you should have come to the court and say, I want to go into this. Why you would think that you could go into it without any advance notice to the court, I don't understand that. And as the defense is pointing out, you're an experienced trial lawyer, and this should not have been gone into.
Your Honor, there have been things in this case, testimony in this case, that I believe opens the door to this. He has mentioned that he's acknowledged that he's used this gun to protect property. He's also just acknowledged that he knows he can't do that. I am attempting to impeach him now with the prior August 10th incident, 15 days prior involving the same gun where he is threatening to use that gun to protect property. I would ask the court's forbearance to do that. I apologize, Your Honor. You're right. I probably should have brought this to your attention earlier. I may have misunderstood your ruling.
You know why it was excluded in the first place? Because it was propensity evidence. That is exactly what 90404 is designed to prevent. You're talking about his attitudes. His attitude is he wants to shoot people. I didn't admit it in this case because, to me, what I've heard in this trial, and by the way, Mr. Richards absolutely correctly points out that just hours ago, I said I had heard nothing in this trial to change any of my rulings. So why?
Testimony, Your Honor.
Pardon me?
That was before the
Don't
defendant's testimony.
get brazen with me. You knew very well. You know very well that an attorney can't go into these types of areas when the judge has already ruled without asking outside the presence of the jury to do so. So don't give me that. That's number one. Number two, this is propensity evidence. I said at the time that I made my ruling, and I'll repeat again now for you, I see no similarity between talking about wishing you had your AR gun, which you don't have, so that you could fire rounds at these thought to be shoplifters, and the incidents in these cases, which are not, there's nothing in your case that suggests the defendant was lying in wait to shoot at somebody or reflecting upon the shooting for a vast amount of time. Every one of the incidents involves matters that involve seconds in time. So I commented at the time, I don't see the similarity, and I don't see the similarity. The prior act has to bear the signature of the accused, or it has to be so similar as to suggest it's a common plan or something like that. You have an incident where he's making comments about some alleged shoplifters versus crimes that involve instantaneous actions, whether premeditated murder or whether self-defense. That's for the jury to decide. But I don't see the similarity. I said it couldn't come in, and it isn't coming in, no matter what you think. Number two, I have to be concerned that with what Mr. Richards has said about the progress of the trial, and when you were I said you were over the line, close to or over the line on commenting on the defendant's pretrial silence, which is a well-known rule. I'm astonished that would have been an issue. So I don't want to have another issue as long as this case continues. Is that clear?
It is.
Thank you. Ask the jury to come back in, please.
A prosecutor must ensure the defendant has a right to fair trial. Otherwise, this whole thing's going to have to be redone. And that's why the judge was so upset. If the jury heard information that they should not have, which materially prejudices the rights of the defendant, there has to be a new trial or the conviction would be reversed on appeal. We've all seen that. Many years later, a conviction being thrown out and then having to be retried. That is a gigantic waste of time and money. It makes the defendant, victim, witnesses all have to relive this thing again in a new trial. It wastes the time of the first jury because now we have to bring in a second jury to do the whole thing over again. This is why judges get really mad when a prosecutor or defense attorney does something that's going to mess up the trial. Still, judges need to have good temperament, and yelling at a prosecutor or defense attorney could give the appearance that the judge is biased against that person or side of the case. The judge should have taken a break and composed himself, but he was visibly upset. So the defense has asked for a mistrial with prejudice, meaning that the case should be thrown out and it can't even be brought again. I doubt that the judge would rule on the motion for mistrial at this point. Normally what happens is that the judge would allow the case to go to the jury, and if the jury convicts Kyle Rittenhouse, then entertain the motion for mistrial. There's no reason to go into this if the jury acquitted him, because obviously these questions would not have impacted the decision of the jury. Hey, I hope you found this video helpful, and I'll see you next time.